We might get started, everyone. Thanks all for joining us tonight. I'm Julie Maxfield. I am a principal in the Commercial and Property Department at Aiken Partners. Tonight's seminar is on purchasing property, and it's the first of a series that we're going to be doing to help buyers in relation to property issues around purchasing. We've got three presenters tonight. Zoe Zhao from Aiken Partners, and she's going to be talking about some of the key terms in the contract of sale and section 32, which we also call a vendor statement. Bao No from Aiken Partners is talking about the risks involved in off-the-plan purchases, stamp duty for first home buyers and foreign buyers, and we'll touch on some issues associated with FIRB, as well as rules around holding a property jointly or as tenants in common. And Carl Powell from Austin Finance will talk about home loans, the borrower power principles, and we'll also touch on home loans for non-resident buyers. So I might get Zoe to come up first, and please make her welcome.
Julie. Good evening, everyone. My name is Zoe. I'm a lawyer in the litigation team of Aiken Partners. Tonight I'll be talking about some of the key terms of the contract of sale and section 32 vendor statements. So, when you're wanting to buy a property and you ask your real estate agent for a copy of the contract, what exactly do you need to be provided with? So usually you need two documents, a contract of sale and a section 32. Both documents will include terms of your purchase of the property, and you need to understand what are included in each of these documents. In terms of the contract, you will usually see particulars of sale, general conditions, and special conditions. Before we delve into more about the contract, the first thing you need to know is whether you are covered under cooling off period. So usually after you sign a contract, you would have 3 clear business days to say you don't want the property anymore without any substantial consequences. There are exceptions to this. The most common one is auction. If you purchase a property from an auction, you will be bound from the moment you sign the contract. So there's no cooling off available. So this is why we always advise potential buyers to conduct their due diligence prior to an auction so that they can make an informed decision about the purchase. First component of a contract is particulars of sale. So usually what will be included in the particulars are details of the vendor and purchaser, a description of the property, the price, how much the deposit, the balance, and the settlement date. In terms of the settlement date for off-the-plan properties, issues might arise if the purchase is subject to finance, and there are delays in the registration of plans of subdivision or issue of occupancy permit. If, for example, the existing loan pre-approval has expired and yet you only have 14 days to complete settlement, the risks of you not being able to settle the property is pretty high. And on this point, Bao will discuss more of some of the options you might have as a purchaser to minimize those risks. The second component of a contract is the general conditions. There are usually standard forms approved by the relevant authorities. The terms within the general conditions are important because they might be varied by the special conditions, and that might affect your interest as a purchaser. And the third component of a contract is the special conditions. It's always our advice to seek legal advice, especially in relation to the special conditions. I will discuss some of the key terms that can very easily turn a transaction into a dispute. For example, in almost all contracts, there would be a whole contract clause. Please. Yeah. Similar to this one. So it says the purchaser acknowledge that the purchaser does not rely on any warranty or representation made by the vendor, any agent, of or any other person on behalf of the vendor, except those set out in the contract. But the purchaser has relied entirely upon purchaser's own inquiries and inspection of the lot, the property, and the land. So this clause will come into play if, for example, you go and inspect a property, and at the inspection, the real estate agent will tell you certain things about the property, things like the size of the property, the previous use of the property, whether there are any known constructions nearby in the foreseeable future near the property. Some of these things might significantly affect your decision as to the purchase. But what you have been told might not necessarily be written in the contract. So in those circumstances, our advice is always to do your own due diligence, because the title search, for example, might tell you that the property is of this much size, or a planning permit might tell you that the property is within, say, a prone to bushfire zone. And those are the things that you would want to know if you are buying a home for yourself. And the rule of thumb is do not rely on any representations made to you unless they are written in the contract. Another common example, especially for foreign purchaser, is a verb approval clause. You might come across clauses like this, which says the purchaser warrants that the verb approval is not required for the purchase of the property. If the property is a foreign person, if the purchaser is a foreign person, this contract is conditional upon the purchaser obtaining the approval within 45 days from the date of sale. What this means is that if you are a foreign purchaser, then you bear the responsibility to obtain the relevant verb approval to purchase the property within a certain time from signing the contract. If for any reason you are unable to obtain the approval, then your contract might come to an end. Usually in those circumstances, any deposit paid to the vendor might be forfeited. In some circumstances, the purchaser might be able to negotiate with the vendor with respect to verb approval. For example, you might want to have more time to get the verb approval, or you might want to limit your loss in case you can't obtain the approval in time. The next example is a clause that would usually apply in an off-the-plan contract. The clause says the vendor will determine at its sole discretion when to proceed to seek registration of a plan of subdivision, having regard to market demand, planning, commercial, practical, and other similar considerations. And given those considerations, the vendor may end this contract by giving notice to the purchaser. And this clause is from a contract of sale of an off-the-plan property that has now been settled. But if we were to review this contract and to give advice, we would recommend against having this clause in the contract. So what this clause entitles the vendor to do is to cancel the contract with the purchaser if, for example, 3 years after you sign a contract and after the property is built, the market is so good that the vendor would make more profit from selling the property to another purchaser. This has actually happened from a past experience where developers would cancel the plan contract in reliance on clause similar to this one, and the purchaser would have very little option but to accept the termination. These are some of the examples which we have come across in our past experience that have created disputes and would even require court processes to solve the disputes. It goes to show how important it is to understand the conditions in the contract and to make sure that you understand the relevant risks if you have to accept certain conditions. Other than the conditions prepared by the vendor solicitors, you as the purchaser can also negotiate on the conditions that are material to your interest. For example, you might want to say that after signing the contract, you have, say, 15 days to conduct your due diligence, including a pest control test. and you're entitled to terminate the contract if you're not happy with the result of your due diligence. Moving on to Section 32. The reason why it's called a Section 32 vendor statement is because, pursuant to Section 32 of the Sale of Land Act, a vendor under a contract for the sale of land must give a purchaser, before the purchaser signs the contract, a statement signed by the vendor that contains the matters and attaches the documents specified in this division. So as the law says, you should receive a Section 32 statement that has been signed by the vendor. And the matters that must be included in a Section 32 statement include financial matters, including rates, taxes, charges, outgoings, any easements, any building permits issued in the previous 7 years, any owners corporation rules, and if there is any services that is not connected to the property. So obviously these matters will provide you with important information to help you decide whether you wish to proceed with the purchase. And if the vendor provides false information or fail to supply certain information in Section 32 statements, then the purchaser may be able to cancel the contract. However, if the vendor can establish that it has acted honestly and reasonably, and that the purchaser is in a substantially good position despite the missing information in Section 32, then the purchaser will not be able to cancel the contract just based on a defect in Section 32 statement. Now I'll pass on to Val, that will discuss the standing.
Thanks very much for that, Zoe. One thing I'll just echo what Zoe has said is that it's really important to get a contract checked before you sign. If it's at an auction on a weekend, you should definitely get the agent to send you a copy of that contract and send it through to us to review. Because as Zoe said, there's so many special conditions that could be in there that are disadvantageous to lots of purchasers. You might not understand everything in the Section 32. So that's why we recommend that we always look at those things first and advise you about those. Is anyone got any questions for Zoe? She snuck off a little quick.
Hi. So with this Section 32, you can cancel the contract during the settlement process if the vendor lied about or was being dishonest. Can you sue them after settlement?
After settlement for
the
non-disclosure?
Yeah.
If you've already settled the property and then...
Yeah.
So that it would depend specifically on the terms of the contract, but as a general, we would say yes, you could still take action after settlement.
The key part to know about this is that what Zoe has said is that if you're in the same sort of position, even though the Section 3 is expensive, then you would not be successful in a claim against the vendor. One of the things you will have to establish is that they have intentionally misled you, knowingly or recklessly. And because that definition is not defined in the law, it will be quite based on information available to you, information available to them. So what Julie was saying is that to avoid all that heartache in the future, get contract advice and make sure that you've been advised on certain important matters in the contract which then typically came to something like that. Yeah.
The other thing I guess I would add on that is that the vendor's obligation under Section 32 covers a vast range of things. If they don't disclose certain things, so say they don't disclose there's a building notice on the property, for instance, and then when we're acting for a purchaser, we do independent searches just to confirm those issues. So we would get a building certificate and that will disclose the building notice.
Yeah.
So that's another aspect of getting the contract checked, I guess, beforehand too, because we will say, well, these matters doesn't appear that there's any disclosures about certain things, but the fact that they haven't put anything in, you don't know about that until we do those searches afterwards. Another question?
There seems to be a conflict with rescission, special conditions, and the vendor statement, because they seem to conflict because vendor statement has to state all the conditions of the property, but then you can rescind special conditions. So,
Not quite following. So the rescission Zoe was talking about was about a vendor in an off-the-plan contract, which is a contract where the plan of subdivision is not yet registered and built yet. So that's a specific sort of contract where a vendor might have a right to rescind. So in a general contract which has already been built, for instance, those you wouldn't find those clauses in there.
okay.
So that just applies, which Val's about to talk to us about off-the-plan contracts. So I might get him to come up and
Talk about the fun stuff. Okay, so buying off the plan, as Julie has briefly touched on, involves either buying something that is on a lot of unregistered title. So it's usually part of parcel that's part of an estate, or alternatively, you buy a dwelling that's yet to be completed. Now, there's benefits and advantages to these sort of arrangements, which I will cover at a later stage, but there's also inherent risk that's involved as well. Now, lawyers are very adaptable, is what I would say. Before the changes in the law, these contracts used to say that if a construction or an occupancy permit is not issued by a certain date, or if a plan of subdivision is not registered by a certain date, then either party can terminate the contract. Now, the Sale of Land Act has been amended to say that the minimum sunset date is now 18 months. And through my experience, I've seen a lot of contracts that's come before me where there are special conditions that purports to not be a sunset date termination. So there are obviously risks behind it. Things much quicker than I am tonight. Andrew?
Not working.
Right. So one of the things that the off-the-plan contracts need to provide is certain warning notices to potential purchasers. One of that is that the deposit has to be 10% and that it's usually held, or it has to be held with a stakeholder. If the vendor has engaged a real estate agent, that's usually contained in the real estate agent's trust account. There has to also be a warning with respect to the substantial lengthy period from the date that a buyer signs the contract and the potential date that they actually may become the owner of the land or the owner of the dwelling that's being constructed. There needs to also be a warning with respect to the value of the lot that can change from the day that you sign the contract and on the day that you actually receive the property.
From you, it's from Andrew.
Am I doing this wrong? Is it you?
No, it's me.
So rescission notice under off the plan, which Zoe briefly touched on, is dependent on the actual sunset date that's written into the contract. So at law, that period is 18 months. Like I explained to you before the changes, both parties were entitled to actually terminate a real estate contract. But due to the change in the law, it's quite strict as to the procedures that a vendor must follow to enable them to actually terminate if they don't achieve registration of a plan or completion of construction by the sunset date. So the first thing they have to do is actually provide a notice, and that notice is a 28 days notice advising of their buyer that they intend to terminate the contract and the reasons why they delayed in actually obtaining the plan of subdivision, but also the occupancy permit that's issued. A buyer does not have to agree to that notice. So you see the shift in the way that these contracts are worded. So if a buyer does not agree, you can imagine as a buyer, you put down a deposit, you may have saved for this deposit for a very long time. 18 months down the track, a vendor then comes to you and says, I'm sorry, I can't get this plan of subdivision ready and I can't get the occupancy permit ready. So I'm intending to terminate. You will feel shafted. Okay, so a lot of my clients will say, no, I'm not going to agree. So in that instance, the owners then shifts back to the vendor and developer, and in order for them to terminate under this clause, they must file a court application. We love court applications as lawyers, but I don't know the normal mum and dad individual likes that sort of process. But that process does involve an application to the court by the developer or the vendor, and the court has to be satisfied of the reasons for the delay and whether or not the developer slash vendor has acted reasonably in order to get the plan of subdivision registered, but also the occupancy permit issued. The court will also consider the effect of a termination will have on a buyer, and it also has powers to order compensation in the event that the contract is actually terminated. So I'm a sucker for this, but I love new things. One of the benefits of buying off the plan is you get new fixtures and new fittings compared to buying an established dwelling, let's say. Another advantage of buying off the plan is your stamp duty savings. So it's assessed on the actual market value of the land and not the complete construction. So if your land is only valued at $200,000, when it's time for you to assess your stamp duty, it will be based on $200,000 and not the entire beautiful value of the construction, which could be $1 million, let's say. That is a lot of stamp duty. Okay? You can also be involved if you're doing a construction sort of process in the design of the dwelling, and the contract price is usually locked in on the day that you sign the contract. So irrespective if the market changes or irrespective if material pricing changes, it is locked in on the day that you sign the contract. There are obviously inherent risks involved. So you're entering into a legal agreement or a promise to be delivered to you in the future. You can't inspect the property on the day that you sign because it hasn't been completed. You are reliant on artist impressions. So a lot of these marketing materials, when you go to these display homes, that's all based on an artist's impression. I think it's because I'm waving my hand so much. But there are also potential unexpected changes that occur. So on the day that you sign the contract, you're advised A, B, and C. There is no way that you can enforce that at a later stage because the process of achieving a occupancy permit, there are a lot of parties that's involved. So the first stage is getting the subdivision across. That will involve the council. The council can issue any sort of demands for you to amend the plan of subdivision, which could actually mean that the value or the sizing of your lot changes or the number and the location of your lot changes. There could be differences in the quality of the fixtures and the finishes. So a vendor or developer legally only has to be obligated to provide you of materials of same quality or similar quality. Let's say you really, really loved a sort of brand or design of a fixture and you purchase this particular off-the-plan complex based on the marketing advertisement by the agent. It will be very difficult for you to enforce that when clearly it can be subject to change. And then I think the final risk for buyers who want to purchase off the plan is that there is really an uncertainty as to what the settlement date is going to be. If an agent confident tells you, we can get this done in 12 months, I would say run for the hills because there is no way to guarantee an off-the-plan settlement date. Not touching this, but let's talk about stamp duty for first-time buyers. So based on the dutiable value, which is usually the contract price that you sign, and now turning back to buying established dwellings or land and not the plan, if you purchase something that is less than $600,000, you will be duty exempt as a first-time buyer. From $600,001 and above to $750,000, you receive a concession. Thank you. Now, the exemption and concession is only available once. If you're purchasing with a partner, say your wife, husband, de facto partner, and they have already owned property previously, this will affect your ability to claim the exemption or the concession. We will go into this at a later stage to talk about the different type of manner of holding on title. You will have to also satisfy the criteria or the eligibility criteria under the first home owner's grant, and that would include living in the property as your principal place of residence for a continuous period of 12 months from settlement. I'm going to now turn to land contracts. So say you are interested in buying a vacant block of land and have intentions to actually engage a builder separately and not go down the off the plan path. What does stamp duty mean to you? Well, it says that if there has to be a new residence that's built on this vacant land, and you must move into this home, whichever of the date that occurs first. So it's either 12 months from the date that you can lawfully live in it. Lawfully live in it means that when an occupant permit is actually issued, or 36 months from the date of settlement. So if your construction period takes way longer than the 12-month period, you still have 36 months from the day of settlement in order to claim that particular concession. So durable value and off the plan concession. So one of the benefits that I previously mentioned about buying off the plan is that stamp duty is assessed on the day that you sign the contract based on the value of the land. The process would involve when closer to the completion of the construction, the developers, conveyancer or solicitor will provide you with what they believe to be the durable value and how much percentage of the construction is completed. There is a process that you then use, a percentage that you then use to try to calculate the stamp duty, but I can confidently say it will always be less than what the entire construction will be. You should also note that there is also land tax to pay on the property that you don't use as your principal place of residence. There is a concept called the absentee owner surcharge. So from 2020, any absentee owner will be charged 2% on land that is absent, and this is assessed on the 31st of December every single year. Okay, foreign investors and foreign buyers. So the definition of a foreign purchaser can be categorized in as a natural person, which is an individual, a corporation, or a trust. But what the law says is a foreign purchaser is not a permanent resident of Australia or an Australian citizen or a holder of a New Zealand special category subclass 444. Now, in order to hold this 444 subclass visa, you have to be physically present in Australia. I have experience in the past where I've acted for a New Zealand couple. They signed the contract on a particular day. They then decided that they needed to go back overseas. They did that. It settled whilst they were back in New Zealand. And the State Revenue's Office said, no, you are not exempt and you are a foreign natural person. So it's very important that this concept is understood if you are a New Zealand citizen and you intend to migrate to Australia and purchase a property here. I also just want to quickly touch on that there is exemptions for buyers who purchase with their Australian citizen or permanent resident spouse. So long that the property is used by them as a principal place of residence, you will be exempt if you're purchasing with an Australian citizen or permanent resident spouse. So FIAB approval for residential property. The concept of Foreign Investment Review Board will apply where a foreign buyer wants to purchase property in Australia. That process will involve somebody applying to the FIAB Review Board for approval before they can actually continue on with their purchase. So we briefly touched on this before, but generally it's advisable that you have a special condition in your contract that tackles this issue, because in the event that, let's say, you sign a contract, it's unconditional, and then FIAB says, I'm sorry, but we do not approve your application. So one of the ways that you can purchase is obviously vacant land, but if you purchase vacant land then the application would generally be approved subject to certain conditions. One of the conditions is that you have to have at least one dwelling built on the land, and the construction of the dwelling must be completed within 4 years from the date of the approval. Go to types of manner of holding. So in order to purchase land in Victoria, there is 2 ways that someone can structure the ownership. So the first is joint proprietors. Example of joint proprietors is obviously purchasing with your spouse, a de facto partner. There is something really unique to this arrangement, and that is called the survivships rule. Basically what that means is you own the property jointly together 100%, but when one party passes away, it automatically goes to the surviving spouse. The law presumes that all manner of holding will be in this sort of nature unless otherwise recorded. So what we do as solicitors, we always advise our clients that, look, based on your sort of circumstances and the way that you are purchasing this property, we advise that the benefit will be either having it as joint proprietors or the other structure, which is tenants in common. People don't have to necessarily purchase with their spouse or de facto partners. They can purchase with their siblings, business partners, any sort of other sort of business structures as well. And so touching on the other sort of manner of holding is tenants in common. So unlike the joint proprietorship manner of holding, the rules of arbitrage does not apply. So you can either own this as equal shares or unequal shares. And it's expected that each party is entitled to dispose of their interests or shares the way they want to. If one party passes away, then their portion will be dealt with by way of their estate, either through probate or the administration process. Like I said, it's usually for blended families, business partners, friends, people who want to enter into some sort of joint venture or partnership agreement where the investment is very different, so you want to record it based on your capital contributions. So I do have some tips for buyers. Number 1, obviously, is get legal advice. We're lawyers, we're not conveyancers by any means. We can give you legal advice, not only on the provisions of the contract, but also the materials that is disclosed in the vendor statement, and also things that we considered should be disclosed in the vendor statement. Carefully consider your reasons why you are buying. Obviously, that will impact the way that if you're obtaining finance, how your loan is going to be structured, but then also the way that special conditions are negotiated into the contract as well. Buyer beware. So there's a concept that purchasers must do their own due diligence, and it's a buyer beware concept. Yes, vendors do have to disclose certain information in section 32, but at the end of the day, you are expected to thoroughly make your own investigation, inspect the property, and purchase the property on the same condition as when the day that you sign the contract, and that's when you're going to receive on the day of settlement. Due diligence. So Consumer Affairs has a due diligence guideline for any person here tonight or online that's interested in purchasing. I can't strongly recommend you download that. It's free. Have a read of that, because those are very important factors in consideration that you could be making inquiries with the real estate agent or seeking your solicitors to make those inquiries. So that's our part. I will now turn to Julie, actually.
Has anyone got any questions for Bao on his presentation? Yes.
So just a quick question, with turnkey investment or planned investment, is there under any circumstances when, because it's turnkey, can they just go back and say, oh, given the construction costs going up and up, at least say, can they come back to us and say, oh, we need to increase the price? Or because it's turnkey, they cannot change the price anymore?
They can't, realistically, legally, they can't change the price, but there could be a special condition in your contract that allows them to do so. So without reading your contract, I can't confidently advise if it is or isn't.
Yeah.
Developers are very cluey, right? So a lot of these developers use big firms to draft these contracts of sale. They're very bulky. So a layman would not be able to just, very quickly maneuver through and find the special conditions to say so. I will say that it's based on what's written into the contract.
Right. And I guess one thing that I'll add to what Val's saying is we're seeing a lot more of late where there'll be a condition, and Val's right, it's in the big contracts, it'll be 300 pages long. You're not going to read all that, but there'll be a condition saying that at settlement, the purchaser must reimburse the vendor for the connection of electricity, sewage, all of that sort of thing. So to me, and to most people, that probably just means $75 to go down to AGL or whatever and get your electricity collected. But the way some clauses are written, what developers are doing is they work out how much it has cost them to connect the electricity to the development, divide it by the number of lots, and then say, oh, your portion is $3,000. So that's why when we see clauses like that, we say, with note, you should have amend this to basically say, this, these charges exclude the cost of bringing the service to the property.
Yeah.
And I should also add, when you're buying off the plan, the developer is actually the person. He's either the builder, or he or she has entered into a construction contract. You have no say in how that's been negotiated.
Yeah.
So one of the things that we often see is that there will be clauses that says, this contract is not a domestic buildings contract. So you got to be very careful if you're going down that path. I'm not saying that it's all doom and gloom, but obviously do your due diligence and seek legal advice before committing to something that big.
Yeah.
Questions?
All right, we might hand over to Carl from Finance to talk to you about home loans. So welcome, Carl.
Thanks for that. I learned a lot today. Why you guys invite me? But nice to see everyone here. Someone I know, someone is new face. So really thanks for inviting me today to have a speaking about the home loan. We will touch on home loan process. We will touch on about how to make your borrow power and how the bank is assessing it. And also why you choose broker than bankers. If there's any bankers here in the office, yeah. And some insights on foreign investors' application. Oh, mine works better than yours. So that's the agenda for today. As I said, we will go through the home loan process, borrow power principles, banker and the brokers, and obviously buyers. If we got enough time, I probably will leave some time for the question and answers. Well, now let me introduce my company, Awesome Finance, and myself. Awesome Finance is a top 25 mortgage broker group of clients that range from first home buyers to high net worth commercial portfolio investors as well, and corporate acquisition and business developers with the complex financing requirements. Our extensive product knowledge, coupled with strong relationships with all the major mortgage lenders, funders, capital investment institutions, means we can satisfy every client need and most suitable products, reliable and convenient service, unique experience that is unavailable directly in the market. I never introduced my company in that way. The word is from Zoe, thanks for that. Like I said, we cover home loan, commercial loan, car loan, self-management, superfund loan. If there's any accountants today, we can talk about that later. And also the program we are doing with Zoe and about today is a little bit basic. I didn't expect so many seniors investors here as well. But the program probably will cover for whole year. We will cover a construction loan, investment, settlement with superfund maybe. We're also willing to, have some feedback after today so that we know what kind of contents we can handle later, right? Well, that's about myself. I'm majoring in accounting and finance a long time ago. I used to be Commonwealth Bank lending manager in different branches. Used to achieve 180 target in the first year. Now I'm mortgage broker, especially after lockdown. Things changing. I need to change my lifestyle, taking care of kids. Father of 4 years, nearly 5 now, old boy. That's about me. But you just need to remember I'm mortgage broker. So if you need to learn, just find me. All right. Before we go to the topic, I really want to know. I think everyone are in the house today, isn't it? Right? Any first home buyers today? No? Right. Do you still remember what's the feeling when you purchase a property? Feel nervous?
Not paying stamp.
Not paying stamp duty. Wow. When is that? Don't talk about it. 20 years. You look so young. Anyway.
I'm young.
Yeah. So, like late settlement, you guys touched on about it. Everybody, nervous about it. And they don't know what's the next step. I want to buy a house. What's the next step? Who should I talk to? Agent? They give me information, but where's the money from? Parents? From friends? From bank? How the bank assess it? So that's all the points we will cover today. So the first step when we do that is first appointment. I know there are a lot of brokers or bankers, they provide really smart way to contact with customer. Like online, you've never seen the person, just make a call, 10 minutes, 20 minutes, get everything done, right? How long I spend with you on the first appointment?
3 hours?
3 hours.
Yeah.
How about Robert?
2 hours.
Yeah, exactly. So I have different feeling about this. I believe when we do the business, especially dealing with your finance, with your personal informations, if I spend longer time with you on the first time, I can understand you more, trust me more as well. And the most important part is you understand what is your situation right now. The first question I remember today is, what's your plan in 5 years, right? Because I'm not just thinking about current life. I'm thinking about what's your plan, what's your next property, what's your third one, how to build your portfolio, because everything related to each other. And the first question I asked Robert is, what's the most important for you on this transaction? You can get the house easily, that's fine. It's not the topic today. The most important is what you want to achieve. Right? That's why I spend such a long time with my customers, in the first appointment. And the next one, doing research and the tailored option. So when we do the research and tailored option, of course we will include how we do the transaction for this time, how to help you buy this property. And also I will let you know when are we going to set up the next appointment. What's the plan, which bank, or what's the option on the table. Collecting documents, pre-approval, I believe everyone knows pre-approval, right? So pre-approval is kind of a pre-application. So when the bank assesses a deal, they will see something about you, about the person. And then they will see the other side, how about the property, because that's a security. Anything happen, they need to get the money from there, right? So the pre-approval means we finalize kind of 70 or 80% application already, which means they already verify all the information about the applicants. If they're happy to lend you money, as long as you can provide good security to me, right? Valuation, that's how they verify the other side. The rest of the 20% or 30%, they're happy with everything, 100% formal approval. They agree to lend you money, buy this property. And then we will organize contract sign up, and then organize settlement, which we need help from Paul and Zoe. And post the settlement is, I always tell my customer, I'm mortgage broker. I'm not sales engineer or David Jones. What I'm doing here is managing the relationship. That's why I spend such a long time with you. And I encourage them to come to see me every year. If things, plan, or life stage may change, right? So that's all care from the post settlement. But the next concern for first-home buyer or maybe investors, maybe more about investors. First-home buyer is easygoing. How we can make your borrow power stronger. What's the logic back of that? Oh, there's a mirror picture, but I love this. I always use the example to explain how the bank assesses you or assess the case. You can think about yourself or your credit like a cake, right? If you have credit card, personal loan, home loan, tax, any kind of debts, it's a piece of the cake. You ate it, right? So how we make the cake bigger? That's the question. Any answers? Come.
My salary was
Yeah, good. We make the cake bigger, right? Then we can provide more to the bank. What else? We give the piece of cake back, right? Exactly, right? What else? We make the cake nicer, more tasty. Like a lot of banks will provide extra or exemption to certain professionals, like a medical, accountant, anyone have good conducts, lawyers, right? You know who you're talking to now? So that's why they care about your practice, credit history, expenses, liabilities, income. Now, when we talk about LVR, I believe everyone knows what it is, loan valuation ratio, is how much of the percentage the bank will lend you. So literally, bank is quite conservative. They won't give you all their money like equal the valuation of the property. They give you 80%. But doesn't mean you can only borrow 80%. Someone can borrow 90% like the professionals I mentioned without loan mortgage insurance. So if just like me or any other occupation, we want to borrow more than 80%, we need to pay extra. So the money is not to the bank, it's not to cover my loan, it's just to pay to some like a QBE or the other one, the insurance company. Then they will guarantee, okay, I believe this person have a good conduct, and then the bank will lend you more. 90%, first time buyer, 95%. We got a bond lender here. They have a special policy, $1.85 LVR, and the low. It's still available, right? Yeah, I checked it before. That's how we make it. Well, next concern. So many lenders. Do you know all the lenders? Big Four here, Suncorp, Bank of Melbourne, St. George, the other version of Bank of Melbourne. Latrobe, we may have about it. What's this? So flexi. I don't know. But they are option on certain customers' table. They're doing well on the low doc. And yeah, they all got different policies. But how do you know the policies? You can easily find interest rate over there. That's what you can do. But what else? After COVID, I started my own business. I only got 1 year financial. What do? Banks say, I want to see 2 years. Well, thanks for that. After 2 years, I can't afford the house anymore. Right? Like myself, I started my own business 2 years. But the first year is nightmare, right? What do I do? Some banks only see 1 year's financial. Some banks even don't need financial. That's how we work. By doing training every week, sit down with one of the BDMs, and then learn the property, learn the policy, learn the nature from them. And then that's the kind of a weapon. So that when I present to customer, when I'm doing the research to the customer, I know, okay, what are we going to do now? 1 year is fine, where we can go. And then after 1 year, we can refinance to somewhere cheaper because you got two financials. Then we can prepare for next year and a year after, or 3 years, or 5 years. We always go one step further. We also were touching about non-residents. I know they were talking about all the risks, and the banks are usually very friendly to like overseas investors. Like in 2015, you may know he's my doing. Right?
No, that is funny.
Okay. 2014, 2015, you can easily borrow money from Big Four. But they shut the door from 2016 until now. They say no to everything. There must be some reason over there, but it doesn't mean you can't get the money from the bank. You still have so much options, like I displayed up there, right? But now, especially after the lockdown, after COVID, we can kind of smell the bank open the gate a little bit. Because things changed. After COVID, I would like to work at home. My home is in Europe. Right? After COVID, I want to stay with my family. My parents getting old. I need to go back to China. Even I'm a citizen here. What do I do? I still earn money from here. I lend money, right? So they start to add some like a temporary visa or some we call it export, which means you have your citizenship, you have your permanent resident, you still can working overseas, and they still accepted the overseas income. Maybe a little bit more strictly, but they still do it. And I think the gate may be bigger. It's not an opinion. So, yeah. I need to be really careful when I speak in a law firm, right? But just a feeling. Yeah, things changing. And Australian, to be honest, they need more non-resident investors to make the economy better. So when is the best time to prepare? That's first-time buyers question all the time. They say, yeah, I'm going to buy a house like 6 months, 1 year, 2 years. What do I do? So we normally will launch your application 4 to 6 weeks pre-settlement minimum. The banks are quite slow now when they're doing the new applications because they're short of staff. A lot of banks, they're hiring offshore staff to do the assessment. Extra. My associate is from NZ offshore team. So 4 to 6 weeks is a really minimum time for us to prepare everything. If it's a really simple, we call it a believer deal, or 24K deal, we just collect everything, just shoot it to the bank, easy. We can achieve that. But anything more complex, if you run your own business, if you have multi properties, if you want to achieve different goals in one transaction, you need more time to do the research, to present to the bank, or even like a mitigant to the assessment team. So from the application to get approval 1 to 4 weeks, that's still reasonable. Depends on the bank. Big Four always quicker. They're rich, right? They can hire more people to do what to do. Pre-approval lasts for 3 to 6 months. So that's really key information to first-time buyers. They used to have some lenders 6 months valid for the pre-approval, but now most lenders only provide us 3 months available. If it's construction, most likely construction will last for 8 to 10 months. So during the construction, the bank still need to deal with your progress payments. And 8 to 10 months, like both said, kind of unreasonable. Yeah, but there's something from our region friends. So anyway, so So why choose a broker? Accountable. Like I said, broker have more witness. We can choose a target straight away after we do comprehensive research. Tailor the solution. But sometimes when we talk about home loan, it's not just about the problem. We talk about your life stage. You first don't buy a single, or you miss a couple. When you got kids, you need space. Like me now, we have second one. My future lifestyle. I need to move to Boland, to big land, to nice place. When I'm getting older, I want to downsize. I want to find somewhere 40 meters to the water, right? So your life stage is changing, and our service is changing as well. Our solution or plan will changing based on your life stage, living your needs. Always commit that because we have so many options. Teamwork and support. So I know a lot of brokers, they work by themselves as like an independent broker. It's quite struggle. I used to try that about half a year. I need to do paperwork. I need to do order collection. I need to check my compliance. I need to do data entry. It's my nightmare, to be honest. But when we work as a team, like our team, I currently leading like 7 people, but in our whole company, we got 30 licensed broker. And if we include all the offshore staff, we may have like 70 people together. We can support each other. Even I'm on leave, my team members stay. And every time when I'm with the customer, we always will add one assistant there. So, which means every question from you, you will get an answer in 24 hours. Help you to close the deal. Well, I can hardly to say that, but when you talk to the agent, because we have a lot of connections to the agent or to the bank, we can give you some tips about how we can take advantage of these transactions. Right, that's pretty much for me today. Any questions? No, easy. Thanks, guys.
Thanks very much, Carl. Thanks to Zoe and Bao as well. As I mentioned at the start, this is the first in a series that we'll be doing. So our next invite will come out shortly. We're not quite sure exactly the topic yet, but if anyone has any suggestions, feel free to shoot us an email and let us know topics that you're interested in, and we'll workshop that and pop it on the agenda. So thanks all for coming, and feel free to contact us with any questions.